if we do get a DEA signaling and they do accept the recommendation, how arduous is that process to actually get to implementation of what the precedent is that Schedule 3 will set? Like, I'm sure there's going to be legal challenges, and then just the framework of the government has to roll out. Like, what does that process look like from a legal standpoint?
Hey everyone, welcome to our latest TDR Cannabis Exclusive, and this is a big podcast here. Many of us have obviously reviewed the HHS newly released document about the benefits of cannabis that came out to public knowledge a week ago. How is this all put together? Well, a lot of it has to do with our next guest as we welcome him in. He is partner of the law firm Coleman, based in Houston, Texas, attorney Matt Zorn. Good to see you, and thank you for taking the time to check into our podcast.
Of course, great to be on the podcast.
Yeah, I think before we get into this, on behalf of everyone within the industry, a big thank you for the work that you've done. I'm sure this was a lot of work put into this, but what was your reaction when you actually saw the documentation that was released last week? And really, in a lot of ways, the reason why this was published was a lot of the work that you put together.
Yeah, I mean, it's interesting you say a lot of work. It actually wasn't a tremendous amount of work. I spent not that much time. I kind of did it on the side. However, I've spent a lot of years becoming the lawyer I am today. So it didn't take me very long in one respect, but it took me a lot to become the lawyer I am today. So yep. I candidly, I released the document before I'd even really read it. My colleague Shane kind of was the first one to go through it. And I have been through it now. And so I certainly have a greater familiarity with it. And it largely says what Shane and I expected it to say and embraces arguments that we were making 4 years ago in federal court as to what does accepted medical use mean. You know, our position has been that this has been misinterpreted by the government for at least 30 years, what this phrase means, that it disregarded what states are doing and what the people are doing, and that states regulate the practice of medicine and not the FDA. And that's the position that Health and Human Services ultimately embraced. And from there, it's really straightforward, right? I mean, it's just look at a map. I mean, there are 38 states now that have medical programs. So the document is longer and it cites evidence and there's a lot to talk about there. But fundamentally, that's what the document says, and that's what we kind of expected it to say. And I'm happy to talk about reasons why this is important, sort of beyond the obvious, but that's
I mean, one thing that's been on my mind since I actually read the document, I mean, and you might be able to shine some more light into this with your expertise. Do you foresee, or do you see this leading to a bifurcation of medical and adult use the way that we see it today in the industry?
That's not impossible. I mean, one talking point that I see going around that I don't think, strictly speaking, is correct from a legal standpoint is that because marijuana is not FDA approved, it really, Schedule 3 doesn't do much of anything sort of on the medical side. I mean, technically that's not true because the FDA's jurisdiction is drug travel and interstate commerce. So theoretically, if you had a Schedule 3 license and you were making marijuana just purely intrastate, kind of think like I don't know. I mean, the FDA doesn't regulate sort of unpasteurized milk on a local farm that doesn't travel in interstate commerce. So theoretically, there's now kind of, if assuming the rescheduling goes forward, there is this kind of gap that once existed that no longer exists, or there's a gap that would be created. So, but generally speaking, it's possible. I mean, Shane and I have written about how it's even possible that the rescheduling is bifurcated in the sense of DEA accepts the recommendation, but then says, but we're rescheduling only FDA approved cannabis. I mean, there are permutations in which this gets bifurcated. And it'll be interesting to see how that's handled. I mean, there are legal arguments for it and legal arguments against it. So it's possible. It's not impossible.
When we look at the original document and then the newly one, a lot, if not all, was redacted. Why do you think that was? Like, what was the reasoning you think, in your point of view, that was behind that?
Yeah, I mean, the government has kind of a reflexive impulse to invoke what's called the deliberative process privilege. If you look at those redactions, you'll see the letters B5 all over them. It's a FOIA exemption, which says that the government can withhold in response to FOIA requests. It's an exemption that says if it's the agency is like forming policy. It's kind of what deliberative process. It's a deliberative process. And so what the agency did was it just kind of went through and redacted anything you'd ever want to read. Looking back at it, I think that the agency's redactions were improper. I think there were a lot of things under those redactions that there was no claim to a deliberative process privilege at all. But my argument in the case was that the document on its face couldn't qualify for the deliberative process privilege because it had the force and effect of law because of the Controlled Substances Act. So it was kind of a niche argument. Shane and I have been doing this for a while and kind of know every case and everything. And so I had a very kind of specific legal argument as to this one document. And then, of course, I also argued that the document had been leaked to Bloomberg and you can't claim a privilege over something that's been leaked. So I had legal arguments entitling me or saying they can't claim this exemption. But that's when you see the B5, and anyone who spends any meaningful amount of time in FOIA understands that the government reflexively claims B5 over anything you'd ever want to know. So that's kind of what you're dealing with. And usually you have to exhaust an appeals process within the agency and so on and so forth. But again, here I leapt straight to court because they hadn't met a statutory deadline.
So the way that Schedule 3 reads, there's a lot of, I don't want to say ambiguity, but there's a lot to be determined as it can actually be applied to the cannabis industry. Things from FDA to actual prescriptions having to be written out with a Schedule 3 substance. There's a lot of conjecture around, yes, there's going to be an accompanying AG memo with a potential rescheduling. Do you think that happens, or do you think that that's mostly conjecture and wishful thinking?
I can't say I know one way or the other on the AG memo. I wouldn't say it's unlikely. Because again, if it's rescheduled to Schedule 3, it remains a controlled substance. And I don't think that most of the current industry, rec or medical, is going to be operating in compliance with the CSA. Layered onto the fact that historically DEA has not given registrations to folks who have been out of compliance of federal law. So you now have that sort of wrinkle, which is the entire infrastructure to deliver this medicine to people. And again, I'm talking about medical, but the entire infrastructure hasn't been operating federal law, and DEA doesn't historically give out licenses to those folks. So, you could see an AG memo again to that effect saying we're not going to count past against future. If the federal government's even trying to get people into the DEA system, it might, there's kind of a lot of different questions to ask here. But I wouldn't be surprised if there's an AG memo because again, Schedule 3 doesn't solve everything.
Right. No, not at all. It arguably leads to more questions than answers with the way that the industry currently is. If we do get a DEA signaling and they do accept the recommendation, how arduous is that process going to be to actually get to implementation of what the precedent is that Schedule 3 will set? Like, I'm sure there's going to be legal challenges, and then just the framework of the government has to roll out. Like, what does that process look like from a legal standpoint?
Yeah, the good news is that there is a framework already. It's the Controlled Substances Act, so there's not too much to scaffold out there on that. Interestingly, there's also this kind of secondary framework that few people pay attention to, which Shane and I litigated and lost in this case, but it has to do with marijuana production and single convention, and there's an entire set of rules in the Code of Federal Regulations that has to do with marijuana production because of the single convention. And nobody's really talking about that. And I wondered kind of, does that get any play? And, we should probably talk about that because under those rules, the DEA has to maintain all stocks of cannabis. And it's this weird thing. But the legal challenges are interesting. If anyone goes and challenges the rule, this could be tied up in court for a while. It's I don't know. What I would be doing is I'd be preparing the army, so to speak. You now have the document. You know at least what HHS their position is, and that honestly under the statute their position on medical and scientific matters ought to be binding. But I would expect that some anti-industry or I don't like throwing the word prohibitionist around, because I don't even think that SAM, for example, I don't even think their official position
No.
now is strict prohibition anymore. They're more kind of like against the industry, but I would expect, them to, or someone in that vein to challenge this, and then this could be caught up in court for a while. There are some arguments on that side as to this analysis. I'm not.
Yeah, I read the Sam response last night. It was fun, comical to say to say the least, where they were what they were grasping at. But I'll leave
Yeah,
that to
one of the
completely.
interesting things about that is, that they're leaning into the 5-part test, which is what I referenced earlier, and it's like,
Yeah,
well, that was a made up test too. I mean, it's like
correct.
kind of like, you prefer the earlier made up test over the newer made up test.
Yeah.
And
Does
You-
this HHS recommendation kind of pour jet fuel on the boys' lawsuit that's currently been that's currently been filed, or help that in any way?
no,
No, it
no,
doesn't.
No.
Okay.
no. The boys lawsuit, and I could talk about the boys lawsuit, but I look, I have dim views of its prospects.
Yeah.
Next week we'll get the motion to dismiss from the government, I would assume, and I assume they're going to argue all sorts of things. They're going to probably failure to state a claim. I mean, look, you have to overturn Gonzalez versus Raich to win that case, which inherently means you have to go all the way up to the Supreme Court. The Supreme Court accepts 40 to 60 cases a year now, or their docket is dwindling. So just, the boys firm is a fantastic firm, but statistically, anytime you're going into an endeavor with the plan of we're going to overturn Supreme Court precedent, you're playing a low odd hand. And it's not the hand I would play. I mean, I would try to find a way to get around the precedent, and try to play at a lower court of appeal to chip away at it, to build and whatnot. So I have dim, but they might even get tossed for lack of standing. I mean, one
Yeah.
thing in federal court is like, you can't just barge into court without an actual injury. And there is pleading towards an injury. I mean, I see the 280E kind of issue is in there, but the government, I would assume they're going to say, like, we don't really enforce this law, so it's not really clear what they're complaining about, in terms of they're asking for an exception under the Controlled Substances Act, but nobody's prosecuting these folks. So
Yeah.
the problem you do with standing arguments is sometimes judges love to latch onto those because it means they don't have to make a hard decision. So if you don't have your standing on really sort of locked tight, a lot of times that's the off ramp judges take. I mean, judges have taken those off ramps with Shane and I all the time. We've had the correct legal argument. You can see that in the Sicily DEA case. We had the correct argument in that case. I mean, that's what HHS just said. Like,
Right.
Yeah.
we argued the correct point, but we didn't exhaust administrative remedies, which is another jurisdictional point, and so the court didn't reach it. So, I mean, I don't have strong views. I don't have strong views about the boys' lawsuit succeeding, but
Yeah, I thought I thought it had a little bit of merit. I mean, it was nice to see with the name associated. But I was reading this morning, people were like, "Yeah, if it gets shot down, that's a negative catalyst for the sector." And I was like, "No, we have a ton of irons in the fire right now, and that getting shot down is not going to set any kind of precedent for a DEA decision, for a negative catalyst. Like, that is completely just blowing it out of proportion."
I agree. I don't think it getting shot down means much of anything. I mean, it's a Commerce Clause lawsuit.
Yeah.
It's not. It has nothing to do with rescheduling, and vice versa. It's about, and I mean, like, if you think intuitively about the lawsuit, that's kind of my deeper problem with it is, it's just hard for me to think that federal courts are going to basically say, like, anytime any industry operates interstate, the federal government can't regulate it anymore. That's effectively what they're asking for. If you really get to the end of the day, is like, as long as some state creates some insular state market, all of a sudden the Commerce Clause doesn't apply. Forget cannabis for a moment. Can that really work across everything? So it's not really a rule that I see the courts, or certainly, again, the Supreme Court, because that's the court you have to get in this case. I don't see it. And if I were to bring a lawsuit, I would, in this vein, sort of Commerce Clause, I would want to be a little bit more narrow and be a little bit more targeted. And of course, we wouldn't get instant relief for the industry in one lawsuit, but it's kind of one of those things where you'd have to really chip away at it. I mean, you look at any if you want to consider this like a civil rights movement or a social change movement, like you look at Ruth Bader Ginsburg, you look at Thurgood Marshall, even you look at the gun lobby. I mean, they don't go for death blows in one lawsuit. They tend to build and chip away at it and file different lawsuits, chipping away at it until the house of cards falls. So, that would be my strategy. The Boys lawsuit is, I think, it's a good press play, but maybe doesn't have the best legal footing.
A lot of moving parts in this space. That's for sure. It's not just an easy rescheduling and all is done, but it gives you kind of a brief understanding as to if we do and get that announcement. Like maybe not the question, do you think it's going to happen? Do you feel more optimistic based on the statement that was released last week?
Yeah, no, absolutely. I mean, let me put it this way, and I'll tie back the Boys lawsuit back into this. This is like mostly a political play.
Yeah.
And so if you view it that way, then it's kind of, if you view this less as just like strictly law and merits and everything, and more of political and trying to raise the profile of the issue and gain momentum, and it's an election year and whatnot, then you see the momentum building, and that's kind of what. I think everyone understands that this is a political process. And so, the question I've been fielding is, when do you expect DEA to come out with the rule? And I say, I don't really know, but I would assume before the election, because I think that is part of what they're trying to go for here.
Yeah.
So, I mean, I think in that respect, you can, and you can kind of see it all kind of coalescing right now towards, and it's positive.
Well, another thing I found interesting is that based on this newly published document, you brought up Shane Penington a few times in this podcast, and he believes that medical MSOs could now be exempt from 280E even without a Schedule 3 classification from the DEA. Do you agree with that assessment? And if so, like, how would that work based on, again, the documents that were published?
I think Shane's position, if you applied to DEA for a waiver and they gave it to the applicant, and yeah, I think there's legal.
So a DEA licensed medical cannabis applicant.
Effectively, I mean, it's you apply for a waiver from application of the Controlled Substances Act, and if it's granted, then yeah, I mean, there's legal merit to that position. But I'm involved in another case where we're trying to get a waiver from the DEA, and they're fighting tooth and nail, and they don't really hand out waivers too often, even on the religious front with psychedelics. I mean, it's not aware of anyone having gotten one. So, I mean, yeah, as a legal matter, I think Shane is correct, and it's different when states do things versus like individual churches in like Nebraska or whatnot. But states justifiably get a little bit more attention, but again, there's a process there too, so it's not just this instant overnight thing.
Mm-hmm. So I mean, we've talked about a lot of the positives that can come out of this. Obviously, it's a huge positive. It was great to see or hear the quiet part being said out loud by the HHS. What are some landmines or what are some setbacks that we could potentially face leading up to or after the DEA ruling if it is Schedule 3?
Yeah, I mean, I did this fight for public transparency, so both the industry could have it, so Congress could have it, so but also so Sam and Kevin Sabet and those folks can also have it. I mean, everyone deserved this document, and they are now analyzing it and I think preparing. And if the industry doesn't do the same thing, then that one negative is one side will have had an advantage over the other. And so I think that's, if you're talking about negatives of the public release of the document versus, I mean, here's the thing, that document didn't change based on its public release. Like it said what it said. So, there's that. I mean, now, again, I think that the attacks in Congress could be against the recommendation, could be sharpened by having the document. But, my personal preference is that things be based on the truth as opposed to, puffing and not really understanding what HHS did and whatnot. I think that, there could be negative effects of the fact that this is out there and DEA is now being, now we know what HHS said and why it said it. And so DEA is under a kind of a different microscope than it was. And maybe it would have been better that this hadn't been released. I don't believe that, but I'm just saying that you could argue the other side of that. And then I think, if you're talking about negatives, I mean, if the DEA does something that is short of what the industry or folks expect based on what the document says, for instance, maybe DEA doesn't agree with HHS or does some sort of rescheduling, that could be a big deflator.
100% it would be.
Yeah. And that's possible, particularly because it's a political process. If the winds seem to blow a certain way or whatnot, it's possible that DEA does something that is, different from what the HHS recommendation says, which is why, getting your legal horses in order to, if you're in the industry, to defend the recommendation, both on the facts and the law. And if you're on the other side, get your horses together to attack it. The document belonged in the public. It belonged to the public in large part because it was leaked to Bloomberg and because it's not a deliberative document. It does have the force and effect of law. That new two-part standard is the law now as to what HHS says is accepted medical use. That was one of my main arguments too, is because I've got another case involving psilocybin, and part of my argument was like, this is what HHS says is accepted medical use, and I need that to show the court. But yeah, so that I think is there are negatives if we don't see action from DEA consistent with this. That's a pretty big deflator for the industry.
Would you?
So what got you into this? I mean, what got you into to drug policy, to moving these social change movements forward, or just gravitating towards these causes?
Yeah, I mean, I'm not a cannabis lawyer. Even today, my clients are not in the cannabis industry by and large. With Shane, I took a pro bono case in 2019, representing Dr. Sue Sisley on behalf of basically medical research that the government was obstructing, and we sued the DEA and we won that case. And I met Sue at South by Southwest 2019. At that point I was a 6th or 7th year associate, and she explained her problem as to she had applied to grow marijuana for research in 2016 and had heard literally nothing from the agency. So I approached her afterwards and said, hey, I'll see if I can take your case pro bono, and went back to the firm. And Shane at the time was also an associate at the firm, and we paired up and beat the DEA once, we beat the DEA twice, and I've been beating them since. I've also lost some cases too. I mean, but I did the 5-tryptamines case, won that case. We got the Office of Legal Counsel memo. That was another FOIA case where we didn't even file a FOIA request. We just went straight to court, and 2 weeks later got a memo out of the Office of Legal Counsel, which is this secret insular office within the Department of Justice. And arguably that was it's a harder document to get than what we just got. And yeah, so I've been doing it. And my personal connection to it is there, I have a personal connection to it with, medical and cancer. And so I didn't have cancer, but, so for me, it's always been a kind of a personal connection and just an interest. I mean, I'm a student of drug policy and drug law, and that's basically it.
Yeah.
I mean, I would certainly, that's kind of why I'm here.
Well, listen, again, a big thank you, I think, for the hard work that you've done. And I know that you're humble about it and don't necessarily want to take recognition.
Yeah, I am not humble about it at all.
No.
On my Substack newsletter.
Was it your newsletter that was like, I win?
Yeah. I'm humble depending on who I'm talking to and when. But.
Yeah. Last thing I'll leave you with, I know we asked, do you think rescheduling happens or not? Let me ask you, would you be surprised if it isn't rescheduled to a Schedule 3?
Yes, I would be if it weren't to reschedule 3. But and I hate to do a yes, but there are different ways that plays out. And I mean, again, I would take a look at I've written on my Substack, ondrugs.substack.com. Shane's written about the treaty issues. And so it's not really clear how that issue gets resolved. And, Epidiolex, they resolved it one way. They could come up with something new. DEA could come up with something new. So I would be surprised if it weren't Schedule 3, but I don't really know kind of where it goes from there.
Yeah, well, time will tell, but needless to say, the ball is now moving, and that's, progress, right?
It is progress, and at least we all now know the truth. So.
The truth. Very good point. Matt, appreciate the time. Let's please keep in touch, and I'd like to have you back on again if we get an informative announcement from the DEA, but this has been great, and thank you.
All right, sure thing. Thanks.
All right, thanks, Matt.
Thank you for your time.
Bye.
Hey everyone, so what'd you think of the video? Leave your comments below and let us know your feedback. We'd love to hear from you. As usual, subscribe to our channel by clicking on the link here. If you want to see more videos like this, then click on the link here and click on that bell for all notifications. Because most importantly, we want to know your feedback because we wouldn't be here without you. Thanks for watching, everyone.